Good morning. Thank you for coming down here today on our very muggy, odd, foggy day. I'm Allie Fannin, Executive Director of the Greater Richmond Bar Foundation, and we are super pleased to be here at Hunton & Williams hosting the first of our pilot program of General Counsel branch of our Pro Bono Clearinghouse. We have been a nonprofit since the early 70s, but we have really been pushing the pro bono envelope since 2001 with our Pro Bono Clearinghouse, giving transactional lawyers opportunity to serve. We've serviced over 600 individual nonprofits, over 1,000 requests, and we just thought this would be a great way to give back to the nonprofit sector in a meaningful way by having volunteers appointed for a year-long service. So we're super pleased that you have come to check out what we have offered in this program. You'll hear more about this from Mike Goldman. Besides the Pro Bono Clearinghouse, we also do the Pro Bono Promise. I know that most people here are from firms that are already members of our Pro Bono Promise, which is a commitment to do your 2% as a firm and to promote pro bono within the firm. And so we thank you for that. But if you have not joined and you're interested, we have information in the back. We partner with the Virginia Bar Association for Veterans Initiative and help them in general civil, veteran specific, a wide array of issues. So that's another place we plug in people for pro bono. And then finally, Justice Server 2.0. If you've never heard of Justice Server, I'm not sure where you've been, but no. I've been working on that project with Legal Aid since 2012. And we are very excited to have the new and improved Justice Server coming this fall. And as you take the trainings later in the program, in the fall, you will also be shown how to use Justice Server to use your general counsel matching as well. So thank you for coming. I would love to introduce Mike Goldman, partner at Hunton & Williams in the corporate finance and M&A practice group, and our very excellent chair of the Pro Bono Clearinghouse Task Force.
Thank you, Allie, and thank you all for coming today to the first part in a 5-part series of trainings that we'll go through for the General Counsel program. Today with me presenting, I've got Phyllis Katz, professor at the University of Richmond, both in the law school and in the graduate masters in nonprofit organizations, I believe, nonprofit studies, very topical, of course, and Bill Gray, tax partner over McGuire Woods. So I'm going to do my best to get the program in their capable hands as quickly as possible. But before we do that, just give you guys a little bit of an overview of the GC program. Obviously, you're here probably because you've seen the request for volunteers and some information about the GC program. And I've fielded some questions, so I know people are reading those things, and we appreciate it. It is, as Allie said, our first year piloting this program, so as you might expect, we're sort of still building out the parameters. So we welcome the questions because you might just raise something that we haven't thought about. But along with myself and Allie, the Executive Director at Greater Richmond Bar Foundation, and Allison Rusi, the Director of Administration, Bill and Phyllis serve on a task force, and there's several other folks that I'd just like to mention. Neil Kessler over at Troutman, Chris Malone at Thompson McMullen, Brian Marin at Spots Fane, and Annette Cousins at the Community Foundation. Together, this group has been meeting regularly throughout the summer to try to put together the parameters of this program. And I know some of them aren't here, but just want to publicly thank them and Phyllis and Bill for all their work getting this program up and running. Quick overview, I think it is a one-year match, and from your perspective as legal counsel, potential legal volunteers in the GC program, what we are hoping to do later this fall, once we get in the applications from the nonprofit organizations, is to match each of you, or potentially two of you, with a nonprofit organization to serve as GC, volunteer, advisor, issue spotter. And I want to be very purposeful with those words because I know, GC has a certain connotation, and I want to make sure that people understand we are not intending this program to be free outside counsel to nonprofits. The goal of this program is really to leverage the great work that the Greater Richmond Bar Foundation has been doing through the Pro Bono Clearinghouse in providing legal services to nonprofits, in providing referral sources. Obviously, the way that program is currently set up, it requires those nonprofits currently to identify that they have a need for legal counsel and reach out to us, and then we can do the referral process. We're trying to take a step further into the process and provide to some of these nonprofits somebody that they can come to as a first line of defense, or they can include in their discussions, whether it's in their board meetings as observers, whether it's somebody that's on speed dial for the executive director, just that has that sort of volunteer, almost a mentor-mentee relationship that they can call you up and say, this is what's going on, in your experience, do you think we need legal counsel? Or we think we do, what do you think, who should we go to? And you guys can be an additional conduit to say, yep, you do need to seek legal advice. That is within my area, I'd be happy to help you. Or that isn't within my area, or I don't have the time right now, but let's reach out to Allison and Allie and Mike and the folks at the Greater Richmond Bar Foundation. Let's see if we have a volunteer within the Pro Bono Clearinghouse that we can connect you with. So that's the purpose of the program. And the program will be a 1-year, January 1 to December 31 match. And I don't know if I already mentioned, but we're hoping to get applications in from all the nonprofit organizations, and we've had great interest within the next month, and then we'll go through the matching process. So one thing as we go through this presentation, this is number 1 of 5. We're videotaping. We will have these posted, so if you miss one of the other 4, you'll be able to catch up and watch them on, I think they'll be posted on the Greater Richmond Bar Foundation's website. So this is not a one-stop, one day, you're going to get everything you need to know to sit in and advise these nonprofits, and you better get all your questions in. Think of this more as, step 1. Folks, you'll see Phyllis and Bill again if you come out on September 27th to Troutman, and then we'll have different presenters on October 11th and throughout the rest of the trainings. But at any point in time, you've got my contact information, you've got Allie's, you can reach out with questions. So pepper us with questions today, but if you have some after you leave, feel free to reach out. All right, so job number 1 of the GC volunteer is going to be, figuring out what your nonprofit does and how best we can help them. And one of the biggest, issues is obviously corporate form. And I want you to know one of the requirements in this program, we're not going to be setting up any new nonprofits. We're going to be dealing with nonprofits who have been incorporated, who have been out there working, who have a decent sizable budget, and who may legitimately have some legal issues to identify. But it all requires an understanding of the fundamental organizational documents of these nonprofits. And while let me see if you can hear me. While nonprofits can be structured as unincorporated associations or trusts or even single-member LLCs, we're going to focus on non-stock corporations today. That is going to be the bulk of the nonprofits in Virginia, and likely the most likely form that they will take in this program. So I'm mindful there is a newer copy, a blue one, but this one's flagged. This is my trusty go-to. The Non-Stock Corporation Act in Virginia, that's your friend when it comes to these types of entities. So we might dive into that a little bit later, but I'll try to keep it pretty high level here. So let's talk about articles and bylaws. And just here, another point on non-stock corporations, their formation, again, something you guys won't be dealing with, but obviously they'll file their articles with the State Corporation Commission. They have to have bylaws and other policies that we'll talk about. And corporate formalities is something that you might understand. That's a there's a range of corporate formalities, and with many of the entities that we'll be dealing with, their idea of corporate formalities isn't the same as the folks in this room, but both with their organizational documents and with their process oriented nature, we want to balance. Help them balance between having proper authorization for actions, but also not having so many logistics in their way that they can't get the good work done that they're trying to do. So within the Articles of Incorporation, this is the foundational document. This is the basic document that you need to get incorporated. And within the materials, I'll just say at this moment, I don't know that we'll get into these forms, but I provided some form articles and form bylaws. If we have some time at the end, we might talk about some of the particular provisions. But as I said at the beginning, feel free to look through those on your own. And if you have questions, you can grab me after the program, or you can reach out at any time. But the foundational document is the articles. That's really what you need to get incorporated. Also, for these purposes, there's some magic language with IRS language, and that needs to be in those articles so that these entities can obtain tax-exempt status. And again, the entities you'll be dealing with in this program will already be beyond that stage, so they should have the magic language in their articles. But when you first get matched up with an organization, we're gonna tell you, here's your packet, here's the articles, here's the bylaws they provided. You should take a look at them. And there's certain kind of recommendations or pitfalls and concerns that you might want to look for. Certain things like staggered boards, terms for directors, and things like that. The Non-Stock Corporation Act, while its mantra is unless otherwise stated in the articles or bylaws, or unless specifically expressed in the articles and bylaws as sort of a backdrop default type code, there are specific things that are required to be in the articles. And I wanted to just point out a couple of those. If you are going to have a staggered board, you do need that. That needs to be in the articles. You can't stagger your board in the bylaws. If you're going to have term limits for your directors that is different than a normal one-year re-election, you got to have that in your articles. So those are just a couple things. If you're going to have ex officio directors, must be in your articles. And Bill will talk a little bit in a moment about members in the context of non-stock corporations. But just as a requirement, if you're going to have an entity with no members, you have to have a clear statement to that effect in your articles. So there's a few little things like that when you pick up an entity, a non-stock corporation's articles, you just want to make sure they haven't tripped a wire or missed a requirement like that. Couple other things, that's where you'll have your registered agent, that's where you'll have your limited purpose, that's where you'll have your charitable purpose language, and your dissolution language that requires that upon dissolution of a tax-exempt entity, the proceeds of any sales or any assets that are remaining have to go to another charity or similar purpose. But from a registered agent, I'll just tell you, because I've seen it a couple of times, a lot of these entities start out and they name a registered agent and they want it to be an individual, and they're certain it's an individual that is going to be with this entity for eternity. We all know that that's not likely and not even possible. We have had several entities come to us and say, our executive director left, terminated, moved out of town, God forbid, passed away. And we just realized they've been our registered agent for the last 5 years still. So that's just one of those things. It's helpful to be able to have enough sense of what the articles are that when you see something like that, you can say, there are these entities and organizations like CT Systems or Capital Services for $100 fee a year. They provide this service and you never have to worry about it. Things like that. We already talked about the magic language of no private benefit or inurement, restrictions on political activity and lobbying, charitable purpose, and the dissolution. You'll see that language is highlighted in one of the forms that I provided. And in a later presentation, Bill will get into all the details of many of those things. So we move on to the bylaws, and just as again a 30,000-foot level picture, if the articles are the foundational document and have very certain requirements to build the structure, the bylaws are the living, breathing, standard operating procedures, the guidelines for how to operate. And this is where when you're looking at bylaws, you're looking at things like notice for meeting, requirements for meetings, quorum, voting, various things like that. You're looking at board structure. Again, how many people? Oftentimes, the articles will say the board will be a size between X and Y, and that's designated then in the bylaws. Those kind of things, you walk into a new organization, you find out they've mandated a board of 15, but they've never had more than 10. There's certain things like that hopefully you can work with through the bylaws, but you can at least be there to spot that for them and say, hey, we need to clean this up. How many people do you normally have? And for a quorum, if you need a majority for quorum, the code, again, in the detail, allows you to get down to 1/3 of your members. But if their documents say they need half and they have 25 directors, that's a big requirement to get quorum every time you have a meeting. Pointing out those kind of things and working with the organizations to make sure that their bylaws actually provide operating procedures that they can abide by, so there's no question as to whether when they take action they're authorized. As I mentioned before, there's very few hard and fast requirements of the bylaws, and the bylaws are a living, breathing document. They should be reviewed periodically. We're hoping that as part of this volunteer match with the nonprofit, that you guys will go in there and take a look at the bylaws and help them understand whether their bylaws and their operating procedures are working for them. If they're not working for them, what kind of issues they're running into. Amending and restating or fixing bylaws is a fairly easy process. It's fairly painless as long as the organization can express to you sort of where they're having problems or what they need. You know, that's a conversation between the executive director and you guys, or the board and you guys, and something that hopefully this program will help them work through. And now I'll pass it over to Bill for some discussion about members with respect to non-stock corporations.
You will find, as Mike said, in the materials, sample articles of incorporation. Those are articles for a non-member, non-stock corporation. But of course, there are two basic divisions in the Virginia Non-Stock Corporation Act between corporations with members and directors and corporations with no members. And then within the membership area, there is almost unlimited variation in what types of membership there can be and what rights members can have. Of course, nobody owns a non-stock corporation, but the members of a non-stock corporation, if there are any, may have rights that are analogous to the shareholders of a stock corporation, at least in terms of the corporate governance. So just as the shareholders elect the board in a stock corporation, you can have a requirement that the members elect the board in a non-stock corporation. The thing is, just saying that a corporation has members doesn't tell you anything at all, because under the Non-Stock Corporation Act, there are no inherent rights of members of a non-stock corporation. There we go. The title member is basically meaningless because the Non-Stock Corporation Act says members have only those rights that the Articles of Incorporation give to them, or if the articles so provide, the rights that the bylaws give to them. So the articles, or perhaps the bylaws, may contain the details of what rights and privileges members of a non-stock corporation may have. And a membership is a personal right. It is not transferable. Among the rights that that can be set forth for members, as I mentioned earlier, the right to elect the directors, the right to vote on other provisions, whether it's whether it's amendments affecting the member provisions of the articles and bylaws, other corporate decisions, mergers, sales of substantially all the assets, etc. And again, those can be in the articles, or if the articles allow, in the bylaws. You can have different classes of members with different voting rights. And you will find also that many organizations have people who are called members but really aren't members under the Non-Stock Corporation Act because they have no governance rights. They may pay dues, and as a result of that get a right to announcements about programs the charity is conducting, or things like that But unless the articles or the bylaws give them substantive rights, Just the title of member doesn't provide any rights at all. Now, we'll talk as we go along about various voting scenarios, but remember that for members, the Non-Stock Act does permit them to vote by proxy, and it also allows them to conduct officer or director elections by mail if that provision is contained in the bylaws. Now, there are also in the Non-Stock Act some fairly detailed rules relating to who is a member, how you determine, and what voting procedures apply in the case where you have voting members. So similar to the provisions in the Stock Corporation Act for voting by shareholders.
Can I break the ice for a minute here, Bill?
Sure.
You guys can please interrupt with questions. I know we're going into some details, but I just want to, one example of how important it is with regard to member voting and how clear your documents are. Not long ago, maybe 2 years ago, two nonprofits came to us and they wanted us to help them with a merger. And as many of you know, members, stockholders, they have statutory rights to vote on a merger. Well, in the context of a non-stock corporation, as Bill was just saying, if you make it clear in your bylaws and your foundational documents that members have no voting rights other than to elect the directors, once they've done that, they're out. Directors get to vote. Well, in this instance, they had some very ambiguous language in there about votes, and each member gets a right to vote on anything that the Act would give them a right to vote on, and then the very next sentence says they only have the right to elect the directors. Well, Bill and I worked on that one together and racked our brains back and forth, and really couldn't advise the organization that, no, your members have no voting rights here, it's not clear. So next thing you know, we got to go out to 40 members who may not even have realized that they were members in that capacity. They may have thought they were more of the, I get my membership newsletter every month type capacity, and here we are requiring 2/3 of them to return a vote so that we could do this merger that everybody wanted to do. So, it's a very easy way to find yourself in a logistical nightmare where clear language in your bylaws could have made it a whole lot easier on the organization.
If I could interrupt, I worked with an organization where they did not keep updated member lists, and when the time came for a vote, they didn't know where they were, how to reach them, or do anything. And they don't realize that little mechanical thing, thank you, of every year updating your list and keeping addresses and contact is important.
Now, as Mike said in his introductory remarks, the rules in the Non-Stock Corporation Act are in many cases default rules that apply unless the articles, or in some cases the bylaws, say otherwise. One very important manifestation of this is in the concept of a member or director agreement. It's a very peculiar provision, at least at first hearing. Section 13.1-852.1 of the Virginia Code basically says that if you don't like the rules that are in the Non-Stock Corporation Act, you can change them in any way that is not against public policy. You can, for example, allocate voting power on a particular issue only to one director, one subset of the board of directors. You can modify other powers. You can put in tiebreaker provisions for a three-member board. If there is ever a disagreement, then one person's vote determines, etc. I mean, very, very unusual sounding provisions, but as long as you put those in the form of a director or officer agreement that meets the requirements of that particular section of the Virginia Code, you don't have to worry about what the Non-Stock Corporation Act says. You can make your own rules. Now, some people might say in that case, well then why don't we just make everything a member or director agreement? The problem is it's a case of being careful what you wish for, because if you style something as a member or director agreement, then there are specific provisions under the statute as to how that can be changed in the future. And for example, unless you say otherwise, a member or director agreement normally requires a unanimous vote to change it after it is in place. So just be aware that there are the provisions in the code in 13.1-852.1 for member directors that could turn this whole thing on its head, that none of the rules that we're talking about today may apply in your particular situation. So with that, we're going to turn then to more analysis of the Board of Directors provisions.
So, just very briefly, and we already talked about a little bit of this, but board composition and structure are key. First of all, thinking of the directors of a non-stock corporation, I mean, just like directors of any corporation, they're stewards. They're there to help guide strategy, help monitor and guide the path of the organization. But in addition to typical director duties with a nonprofit and a non-stock corporation, they're also fundraisers. They're marketers. They are, the main champions of the organization and its cause. So it's important to have your board structured properly, so you have, in many cases, the right touch points in the community. It's many things to think about. It's also very important to be able to refresh and get new blood on the board. We have lots of organizations come to us, want us to review their bylaws and say, we've had the same directors for umpteen number of years, and we really want to get some new, fresh blood in here. How do we do that? And sometimes we do that politely by moving to term limits and a staggered board. Other times there's various ways. There's also things like advisory committees and honorary directors, where you want to keep people involved because you want as many marketers and as many fundraisers and as many champions for your cause as you can. But you don't necessarily need 39 overseers and strategy, people on your board. So there's ways to use committees, and Phyllis will talk a whole lot more about committees and the board. We were going to review some sample articles and bylaws provisions. I talked about some of them earlier. You've got the forms. I know I'm very mindful of our time. I'm going to skip ahead here, and if we have time, we can come back to it at the end and talk through some of the forms. But we got some more meat of the presentation to get to here. Just want to hit off from the beginning. It is critical, and right from the start, with new directors or a new board, that there is an orientation process. I would say one of the key things, if you're going into an organization as a volunteer and you're looking at their policies, their procedures, if they don't have a process or an orientation process for new directors, or they don't have a board director manual, which sounds very official but can be as simple as a binder with the articles, the bylaws, conflicts of interest policy, things like that, that would be a number one recommendation that all of these organizations should adopt, and something that certainly as a volunteer or through this program we can help give them some recommendations on how to do that. Annual IRS information returns, what the committees are, where the organization's income and financial support comes from. Those are very important things for all the directors to know. So to have, whether it's as simple as the first meeting when a new director is elected or appointed, that they come an hour early and they get a brief tutorial from some directors who have been there, or from the executive director, and they're handed their binder. It could be as simple as that. It could certainly be much more in depth for some of the larger organizations. But it's key that there's some process so that directors, when they're stepping in, understand the overall structure of the organization, and also understand their expectations as directors. And that goes all the way down to number of meetings, how many times they meet in person, telephonically, how they operate business. Like Bill said, we might need votes, and we might need them quickly, so you got to pay attention. You might get an email looking for a vote. We're going to need responses. And then there's obviously the last one where, board fundraising. What's the expectation on directors, giving to the organization? Something like that is something you want to get out there, and you want it to be clear what the expectations are from the beginning, so when the director steps in, they know what they're stepping into, they know what they're signing on for, but they can also hit the ground running. And now I'll turn it over to Phyllis.
To take a break. How many nonprofits do you think there are in Richmond? And I'll throw out three figures: 4,000, 6,000, over 9,000. 50,000, no. There are over 9,000 in Richmond. There are over 60,000 in the state of Virginia. Virginia ranks 12th in the country in the number of nonprofits. Now, that is including all the 501c4s and the political PACs and all of that we have a lot of. But to rank 12th in the country is amazing, and that is the size of the market. I can't reiterate the importance of an orientation package. On every board, I don't serve on boards anymore. And the most recent one I served on, I got on and got off in 2 months after I rewrote the bylaws, because when they recruited me, they said something that made absolutely no sense to me, and I said, let me see your bylaws. And I found out that they were operating with only 3 members, 3 directors, when their articles of incorporation said 5. And no one had to read them, period. They didn't care. We're meeting, we're fine, we're managing the money. And over and over and over again, the laxness, particularly in a smaller nonprofit, that is shown to the formalities that we all concern ourselves with, is really critical. I'm going to go quickly through duties of board members. This is the code provision on the duties of board members. But I wanted to stress, other than what the statute says, is if the duties are not going to be performed by the board, they must be delegated, and there must be some legal delegation. This is another area where I have repeatedly found organizations remiss in delegated authority to either their officers, to whatever. In the most recent example I gave you, where they were working with only 3 board members rather than the mandated 5, when I rewrote the bylaws for them and got off the board, I only went to 2 meetings. The treasurer said to me, well, I never do those duties that are in the bylaws. That was the first time they ever looked at them. Why are you laughing? It's true.
It's common. It's very common.
From experience, I learn. So let me, here the important takeaway is the delegation. Make sure that whatever delegation occurs, that there is something to protect the organization from just giving it away and saying, do as you wish. Here are the standards of conduct under the Non-Stock Corporation Act for the board members, and the common law duties are the duty of obedience, the duty of care, and the duty of loyalty. My favorite one, of course, is the duty of obedience, being an attorney. There is a concept in nonprofit law that comes from the IRS code, which, if you could stress to an organization, is essential. All nonprofits must be organized and operated in furtherance of their exempt purpose. And most don't even know what their exempt purpose is. I mean, they know what they do, but they don't know what the legal exempt purpose is and what the constraints are. The duty of obedience is to make sure that you're following your articles of incorporation, your bylaws, the laws that pertain, and all that is the legal, I like to say, the skeleton of the organization, the backbone. But organized and operated, and any enforcement actions that IRS does, they go back to how you were organized, how you were operated. How you're supposed to operate under IRS law are one of the things under the other than the Non-Stock Corporation Act is under IRS code. There is a stringent prohibition on private interment, private benefit. That means insiders don't benefit financially or in any other way, or you bestow your benefits on a discrete group of individuals. It has to be a charitable class. Limited advocacy for 501c3 and all the organizations you're working with, and are that limited lobbying and absolute prohibition on political activities. You have a distribution requirement that you can only distribute your funds in furtherance of your charitable purpose or to other charities. There is a strong prohibition on or financial consequences with ultimately the loss of tax-exempt status if you engage in unrelated business activities. That's a trade or business, selling goods, and often you hear nonprofit boards saying, let's act more business-like. We can make money doing this, we could sell this. Sale of goods, merchandise, and services is a business. And if your organization engages in that, they can, it is not prohibited, it's taxed if it's unrelated, but if it gets to be a predominant function of the organization, then they can lose their tax-exempt status.
And Phyllis, if I might add, we're going to go into a lot more detail on some of these tax issues in the third training session. So this is kind of an overview, and then we will maybe get farther into the weeds than you ever thought you wanted to get in a couple sessions from now.
There are standards on investments. There are all of these standards that all fall in the duty of obedience. And I think the organization needs to educate its directors on what these parameters are. I have never worked with an organization that was so highly constrained by state, federal law as to what they can do, and the boundaries are there. The duty of care and good judgment is to simply be there, read what you're voting on, know what's before you, and ask the meaningful questions. You must discharge that duty in good faith business judgment in the best interest of the corporation. If you get nothing beforehand, how can you take any action at the board meeting? So making sure that there is an orderly flow of documents that are necessary for board deliberations, and that whole process of what comes to the board is important. The last one is the one I love, is the duty of loyalty. Is to act in good faith. And your decisions should always be in what is in the best interest of the organization. But I find in nonprofits, the duty of loyalty can be breached in subtle ways, and I'll give one example. I've sat on boards where I've learned that a foundation had approached the organization and was willing to give out grants for a certain area of services that it felt needed in the community. Well, the board member sitting on that board should not take that information and share it with another organization. Even though the foundation may be a very public document, it has not disclosed that information. So I find often serving on dual boards can create a conflict for some board directors in how you silo what information you get from one board to another. There should be board oversight under private inurement, private benefit, and I've put in a lot of information later on this. But in this area, there is personal liability more likely to occur if it's not carefully watched for each board member. And I haven't moved my stuff.
I got you.
Would you do the next one? Good. I don't do well. Failure to monitor is the next one, can result in liability. And most recently I read, and I put it in here just for your information, $5.5 million against the individual directors because they didn't watch the money and where it was going to, and it was private inurement. Insiders were trading and purchasing goods and investing in their own stuff. So you're not insulated. The corporate shield doesn't protect you from personal liability if you're outside the scope of your authority or the rules that we just talked about. We've talked about the next one, if I can do this. Oversight of business activities. You can only incidentally engage in those, and there's a whole section we'll have on this later, but here are general prohibitions on that. I'm going through these quickly. Give you all. Political campaign and legislative advocacy. The area of advocacy, lobbying, and political activity are three distinct. You can always, as a 501c3, advocate for cause issues and bring issues up without being a 501c4. Lobbying means you're down when a bill has been introduced into the legislative body. So once a bill has been introduced, whatever stands you take are then lobbying. And you can do minimum lobbying. You cannot do any political activity. And today, it's harder to know when a candidate declares his candidacy. But once there is a declaration of candidacy, you've moved into the area of political activity. And it is one area where organizations have often gotten into trouble in getting involved, and particularly since we're in the Capitol, it's easy to move from lobbying, advocacy to lobbying to political activity.
And if I can interject one more thing here. This has been a source of a lot of concern from charities over the years, because the code says simply that lobbying or attempting to influence legislation cannot be a substantial part of a charity's activities. But nowhere in the code or the regulations is there a definition or quantifying of this concept of substantiality. That made charities historically very nervous, because if they stepped over that line, then they didn't qualify for any longer for 501c3 status, but they didn't know where the line was. So for years, charities complained about the indefinite nature of that test when in an area that was so important to their tax-exempt status. So finally, and it's been 20 years or so ago now, Congress came to their rescue with Section 501H. The complaint was, we have no standards to measure our lobbying by. So what Section 501H does is to provide some dollar measures of how much lobbying a charity can engage in. And there are limits, annual limits, based on the budget, the overall budget of the charity, that provide for how much of your budget you can spend on lobbying in general, and how much of it can go for grassroots lobbying, that is, attempts to influence the public on a legislative matter rather than direct communications with legislators and their staffs. The grassroots lobbying component of it has to be no more than a fourth of the total allowable amounts. And people say, why did Congress decide to do that? My cynical answer is because Congress wanted more of the lobbying money spent on it than on political, than just on public debates. But in any event, the reason I bring all this up is that charities now can decide whether they want to be judged under that substantiality test, whatever substantiality may mean, or under the 501H, very specific dollar test. Charities that don't do much lobbying probably don't care. Substantiality, like pornography, is in the eye of the beholder. And they may just know that what they're doing on the lobbying side is not substantial. But if a charity is getting close to the line or fears that it may be, then it may want to make a 501H election. Now, that's one of the things that you may want to check for a charity that you are advising, is whether they have elected to take advantage of this dollar test safe harbor. The other advantage to the 501H election, not only does it give you bright lines, but if you go beyond those amounts, you don't automatically lose your exemption. Only if you repeatedly exceed the amounts by more than 150% is your exemption in jeopardy. So many charities may be concerned about their lobbying but don't know about the 501H election, and that may be one thing that you could point out to them. If you are concerned about this, here's a way to take care of it.
There's two things about the 501H election that I like. One is you can elect and then revoke if you want to go under the facts and circumstances, substantiality test, so you can revoke it at any time and restate it. The other piece about it is volunteer time is not counted if you make the election. If you don't make the election, you have to track volunteer time and everything. But whichever method you go, most organizations I know don't track at all. And you can't report if you don't track. So making sure there are procedures to track advocacy activity is very important.
And also some things that you or I would think of as lobbying in just normal everyday English terms, the code doesn't consider lobbying. So some charities are surprised to find that many of the activities they might want to conduct in the legislative area don't count as lobbying at all.
There is really a lack of knowledge in this area by most charities I know. We're going to talk next session, not this session, on solicitations, but there are basic rules that have to be followed, and the important thing for a board member is to know that there is annual registrations and reporting, and every board member should look at, in my opinion, whatever's being filed with the Office of Charitable Solicitations and Regulatory Programs, because it is a public document. The financial statements are, the document is, it's all very, very public. And most of the time the board never even knows whether they filed or let alone saw that document. There are provisions for notice and other requirements in the Virginia Non-Stock Corporation Act. And then I have one thing, I always put this in because I have searched the Non-Stock Corporation Act for what officers are required. And none are required, but there is only mention of a secretary is the only officer that even gets the word inserted into the act. So your bylaws and articles of incorporation will determine what officers you have and what those duties are. But the role of the secretary, I feel, has a very important role. It's more than custodian and record keeping. They're responsible for keeping the corporate records and keeping them detailed enough to protect both the organization and the individual board members from liability. One classic example in minutes, which I'm going to get to next, is to record the votes by who dissented. Because the presumption is, if the minutes don't reflect, the corporate records don't reflect who voted against an action, that action may have legal liability, then everyone is presumed to have voted. They're not going to sort out, they don't care, the recollections. It is the minutes that reflect that. And oftentimes, the minutes simply say the motion passed by a majority vote, period. And you'll have no defense to argue. I never thought, I am the least detailed person in the world, that I opine on minutes, but I really find them to be so inadequate, and I've listed points that I think should be what included in the minutes. But one of the things that my local government clients, when I practiced in that area, did, and I find it very efficient, although bulky, but now with electronic storage of documents, it's not so, that everything that went to the board for them to review before the board meeting gets right incorporated in the minutes. So you have a contemporaneous document right there attached to the minutes. I think it makes it, today with electronic, it doesn't matter, but it's very, very efficient to have that there rather than to say, this is the version of X document that we looked at. The document that was before the board is right there attached. So we would go to board meetings, and this is how thick the board packet looked. Corporate policies.
Let me suggest something. Since we're shifting now from the basic documents to more individually crafted, I wonder if we ought to stop and see if anybody has any questions or comments about articles or bylaws before we go into the next section.
When is it advantageous to form a non-stock corporation without members?
When is it advantageous to form a non-stock without members? If you want, if you are content to have all of the power and authority focused, centralized in a board of directors, then there may be no need to impose another governance layer on top of that and have members who have certain rights that otherwise would belong to the board. The membership structure, I think, is more useful either when you're trying to promote public involvement or when you have a situation where corporation is to be related to another entity. We're going to talk a little bit later on in the session about affiliates and subsidiaries, but a membership is often used as a way to create a subsidiary. You know, there's no stock in a non-stock corporation, so you can't have a sole shareholder or a group of shareholders. But you can have a member, a sole member, or a group of members. A member doesn't have to be an individual. So, for example, if an existing charity wants to establish, separately incorporate an endowment fund, one way to keep control of that endowment fund is to make the existing charity the sole member of the endowment fund, give it the right to appoint the board, for example, and perhaps to vote on other key points like any changes in the articles or bylaws or any changes that would affect the voting rights of members. So, you know, there are a number of situations when it could be useful.
If you're a non-stock without members, then your board of necessity becomes self-perpetuating body.
If you are a non-stock without members, then either you're going to have a self-perpetuating board or there's going to be some other mechanism in the articles for the board. You could have, for example, a board that was made up entirely of ex officio members, that is, people who are on that board by virtue of some other office they hold somewhere else. You know, if you've got a for-profit corporation, for example, that is setting up its own charitable foundation, it might say the board of this charitable foundation will consist of the following officers of our corporation. So, you know, again, there are different ways that you can handle that.
Yeah, I'll tell you, I usually come at that question from the opposite. When is it advantageous for them to have members? Because we have a lot of folks come to us, particularly on the front end, if they want to set up a nonprofit or a non-stock corporation, and they say, you know, we ask the question, do you think you need members? And of course they look at us and they oftentimes don't know why we're asking the question. But in my mind, unless you have a group of 2, 3, 4 founders who, you know, this is sort of their baby, and they want to retain some control and particularly retain some voting rights over major actions, whether it's, you know, dissolution, merger, you know, sale of substantial assets, change of purpose, that kind of stuff. If you have a group of founders that want to retain some of those voting rights in the members, well, then you know, it may be worthwhile to have members or classes of members in that case. But if you have a group that, you know, really from a member's perspective, all they want to do is be able to appoint the board, and then they want the board to handle, as Bill said, your articles and bylaws can set forth the structure of, you know, election or appointment of directors, whether it's ex officio or whether it's by the, you know, current board elects and has a process for nominating and electing, you know, the next board and term limits and things like that. So in my mind, unless there's some good reason to, you know, have members, particularly individuals and founders, then, you know, I often counsel folks that, you know, for the various reasons of maybe not knowing exactly what voting rights you've set aside to the members, it oftentimes makes sense to have a no-member non-stock corporation.
Just maybe a more practical or real life, I guess, maybe. We're all lawyers here, I guess, and we all understand the statutes, regulations, requirements, and all this stuff. But these members of the boards who are not lawyers, you know, I've heard, oh, you lawyers are nitpicking, and it's just, why are you doing, what's the difference? And so I was wondering if you guys, how you address that when you say, well, you need to do this because the statute says so-and-so. I would think that non-lawyers probably don't care about the statute, and wondering why you're being such a nitpicker, and how do you handle that?
I always ask if they care about personal liability, but I mean, you're absolutely right, and that's the immovable force that we're always up against. Is, you know, is this necessary, or is this just one of those things that is a nice to have, check the box kind of thing? And I think it is a spectrum between balancing, you know, having things properly authorized and having your directors properly protected, and practically being able to get through a meeting and get something done. You know, I tell most people that when advising nonprofits, my goal is to identify and remove obstacles for them, and then get out of their way so they can do the good that they're there to do. So, I mean, it's a constant push and pull, but I think there are certain things like, you know, if you have, or if you don't have something in your articles that the code says has to be in your articles, but you've been operating for years with, you know, that's either nowhere to be found and you've been operating that way, or it's in your bylaws, well, that's ineffective. And the folks in that room, you know, could be opening themselves up to personal liability. So yeah, this is a little bit of a painful thing to have to look at a code section and, you know, parse the commas and read the clauses and figure it out. But at the end of the day, if it says this must be in your articles, you know, they're all going to be very appreciative when the lawyer finally points that out. We put it in the articles, and everybody can breathe a sigh of relief going forward. So, you know, some of these things I would agree are more of the nitpicky variety, but I think the ones that go to, you know, authority. Thank you. Authority and validity of actions, I think those are the ones where it's just important for the advisor, the legal advisor, or the lawyer that's on the board to stand on their head a little bit for those things.
And it may be a little easier on the tax side because people fear the IRS. You know, they know that loss of exemption is a possible penalty. So if you tell them that there are things they have to do to comply with the tax code, then of course that's perhaps an easier sell than it is with some of the other corporate housekeeping issues.
Any other questions on the foundational documents or more of the articles, bylaws, things?
If I could add one other point, everybody in the room may know this, so I may be stating the obvious, but the Non-Stock Corporation Act also is very protective of officers and directors who try to do the right thing. And you know, 13.1, 870.1 is another provision that everybody ought to have right on the tips of their tongues, because that is the provision that says if a director of a non-stock acts in accordance with his or her good faith business judgment of the best interests of the corporation, the maximum personal liability that individual can be subject to as a result of actions taken as a director or officer is equal to the amount of compensation he or she has received for service in that capacity during the preceding 12 months, which means that volunteer directors and officers have no personal liability as long as they've acted in good faith. You know, there are exceptions for willful misconduct and knowing violation of the criminal law, but there are also those pretty powerful protections in the Non-Stock Act for officers and directors who are trying to follow the rules.
All right, folks, I think we're going to get started. Please continue to grab some food over there and eat and listen, and Phyllis will kick us off on corporate policies.
There are two documents that I wanted to mention to you that are not policies. One is the Form 1023, and that is the application for tax-exempt status. And in board orientation packets, they should be there. They're public documents. They should be posted. The other is the Form 990, which is the annual return that exempt organizations have to file. The 990, one of its goals was to deal with governance issues. And on that form, they ask if the organization has various policies. IRS does not mandate any of the policies, but the Form 990 is a public document, and it would be very nice if an organization could check, yes, I have a conflict of interest. We have a conflict of interest policy, because the question is asked. So I'm going to go through some of these policies and identify what is on the form, what is not. There is a site I want to give you called Richmond Gives and .org, and it's run by the Community Foundation. Because the 990, the 1023, all have to be public documents, this site has served as a location where organizations can post their forms. If you're working with your organization, it would be a wonderful thing to look at the site and study what their past 990s have said. Plus, on that site are also their financial statements. And it is a wonderful window. And it was intended not for lawyers, but for the general public, because the whole idea of both IRS and the state law is to make as much public as possible so donors will have knowledge and be informed. What is the organization, how is it running, and all of that. And the Community Foundation has set up this portal, which I find to be extremely helpful in looking at the organizations. Okay, so we're going to get on to policies. None of these policies are required as a matter of law under tax law. However, Sarbanes-Oxley has whistleblower and conflict of interest for corporations. So every one of your organizations should have a conflict of interest and a whistleblower. Most don't even know what a whistleblower policy is, let alone have one. And conflicts of interest really help the board protect themselves against liability. And there should, in my opinion, be a board conflict of interest which has similar positions as staff, but the potentials for conflict of interest with board members is greater, so there are certain duties, and we're going to get in on other sessions on disqualified persons and benefiting from the organization and all of that. So there are special provisions under conflict of interest that I think should be designed to the board. Most of the organizations have in their directories very personal information about people. They should have a policy on privacy as well as cybersecurity. A document retention and destruction policy, financial management policy, investment in funds. We're going to be talking about the Uniform Prudent Management of Institutional Funds Act, but there are all kinds of requirements on that. One of the areas, and I hope in the next session on contributions we'll mention it, but if I don't, I'm telling you now, is one of the faults. Most of the organizations I work with, they don't understand what a restricted gift is. So they don't even track it. And if you're raising money for the hurricane right now and the victims of the hurricane, and you solicited for that, it could arguably be a restricted gift. So policies on gift acceptance, who can accept it, what conditions should be in that acceptance, and what could be imposed. I also advise tracking of contributions that are restricted. Again, I had run into an organization that 40 years ago had been given some real estate that they converted to cash, and it was for a restricted purpose, but they spent the money that was the equivalent of that, but they never charged it against that fund. So they don't know how to keep and track expenditures from restricted gifts. There's governance policies, risk management. The 990 asks about joint venture. Do you have a joint venture policy? If you check no, you may not need it, but it's asked on the 990 every year. Compensation, again, to avoid private inurement, private benefit, a compensation policy I think is essential. They may want to have a social media policy, what they put on there, who's monitoring what they're saying. That's probably more sophisticated than most of the organizations that you'll be working with use. How do you hire consultants? What is their role? And personnel policies and employment, we're going to have a whole session on that. I'm not going to get into that. But volunteers is the last one where I often find organizations very remiss. They don't have a volunteer policy, both screening, hiring, supervising, and monitoring what they do. And I believe that volunteers should have it. Stanford Law School, in their transactional clinic, has prepared legal documents for nonprofits, and they're very good templates. Most of them were not relevant for anything I was talking about today, but the one on volunteers was so extensive that if I had to sign that volunteer agreement, I probably wouldn't agree to work with them. But it is a good resource to look at. Stanford, it's their transactional clinic, nonprofits, and they've posted perhaps 25, 30 different agreements and policies, including joint venture and others, that may be a good resource.
It is really, I mean, it's amazing how much they've put out there. And I just noticed it's not on the resource slide at the end here. We'll send it around. We'll send that link. I immediately put it in one of my favorites, for this area, just so you can check it. I mean, granted, it's not tailored to Virginia law, but it gives you a framework to look at, especially the policies, a framework to look at it with, and something to work with if you're starting fresh. Just want to interject one thing. You asked the question earlier about getting pushback on some of these things, and are you just being a lawyer and being nitpicky? Hear that all the time on these policies. I mean, do we really need a policy? Do we really? Why? Can't we just do it? Do we really need to spend the time to put this policy on paper? It's not required, as Phyllis said, but again, highly recommended, because particularly with the conflicts of interest policy. Conflict of interest policy, is there so that, if you run into a situation where you want to do a transaction where there's a potential conflict, it's there so it outlines a process where you can still do that transaction and not get in trouble for it. So there's disclosure, so everybody understands it. Everybody's signed it. They understand their obligations, their disclosure obligations, and so the board can make a decision as to, okay, we've got all the information in front of us. We understand the potential conflict. We recognize it. We either agree it's not material, or we, notwithstanding the potential conflict, this is in the best interest of the organization to move forward. So, I mean, these policies, set forth a framework so that the entity can operate and can stay out of its own way.
And a lot of these are really self-defense measures for the corporation, rather than trying to craft a policy or figure out how to handle a situation when you're in the middle of it and you have to deal with the politics and the personalities in addition to everything else. If you can have thought about these types of situations beforehand, then you're much better equipped to deal with them. And that relates, not only to the internal workings of the corporation, but also, as Phyllis mentioned, to things like a gift acceptance policy. If you have a gift acceptance policy, you may be in a position where you can say to a longtime supporter, an important donor, gee, Ms. Donor, that is the whitest elephant I've ever seen. It is just a wonderful example. I'm sure you've taken great care of it, but our gift acceptance policy won't allow us to accept white elephants. And those types of defenses can be invaluable. The only thing I would say is you got to be sure that the policy fits the organization. There are, for example, a lot of gift acceptance policies floating around out there on the internet. Some that consultants have put up, others that have been posted by particular charities. You can't just go to one of those, substitute the name of your organization for whatever name is there, and think that you've done your job. You've got to make sure that it fits the gift program of that particular organization, because the only thing worse than having no policy is having a policy you don't follow. So that's an important consideration.
They don't have the policies, and they don't understand why. And back to Bill Gray's comment, oh, why do we need another lawyer on this board? And I usually say when I'm asked to serve, you don't want me on your board. And I feel much more comfortable not being on your board. But having these policies, the other thing that I really recommend, and this is not legal, but one of my biggest disappointments last year in teaching was I had both the law student class as well as the graduate student class work on a conflict of interest policy using the Model 1 that IRS has. And there's one that IRS has in publication 557. And I stressed to them that the policy means nothing if the people who are using it don't understand it. So try to make it understandable and give examples. And both classes failed so much on that. And it's a simple little thing of taking a policy and giving it to the average user and say, what does this mean to you? And how is it going to affect you? And getting them to understand, and then putting in a few examples. Most of the policies, including the IRS one on conflict of interest, doesn't give any examples of cases when you need to say you have a conflict or disclose. So working with an organization to help them put meat, as I say, into the legalese of a policy is really helpful. I think I'm on my last slide. I'm almost on my last slide. Governance. One of the things that, again, I have never, in all my time on any board, been shown the 990 before it was submitted by the organization. Yet, on the 990, it asks the question, did the board review the 990 before it was submitted? Come on,
But again, there's no penalty for answering no.
no, that's right. There is no penalty for answering no, but they ask the question, and if a big donor wants to come, they want to make sure the board has somewhat oversight. And the second thing, back to my stressing minutes and all, is this is the other question. Was there contemporaneous documentation of board and committee meetings and actions? And I rarely have seen minutes of committee meetings, rarely in the nonprofit sector. Yet there should be, if they've been, particularly if they've been delegated authority. And both questions are asked. My advice to nonprofits is, this is the public document that's out there for the world to see. You want to check, yes, you have this policy, yes, you have these practices, because this is IRS's effort at good governance.
And whether it's applying for a grant or seeking a institutional donor, you know, lots of the granting organizations or foundations or large institutional donors, you know, they love to see great purposes, but they also are going to look behind and make sure that the board's doing their job. And they are the kind of, you know, entities or organizations or white elephants, to use Bill's term, that might look and see, he answered no, and that's not a big deal to the IRS, but it's kind of a big deal to us. You know, are you guys going to, you know, review these things going forward, and does everybody know what's going on? So, you know, these public documents in the 990s, they're IRS documents, but they're also marketing tools, and you don't want something as simple as sending a document out in time and having folks review it and being able to check that box yes to inadvertently, you know, kick you out of potentially a large grant or donation.
And one last thing, and this is not to discuss, but what I found interesting is some of the major foundations post their policies right on their webpage. And I put down the Ford Foundation in particular because it has the most extensive list, but it is a good look if you wanted to look at what some of the policies may be for a major foundation. And I do get obsessive about searching the web now that I'm retired. I have little else to do, but I stopped after the Bill and Melinda Gates to see what policies they posted, so I put them up. But you could probably find other major foundations that are, I mean, they post them right on their webpage of their foundation. Here are our policies. And this is the importance that they feel about good governance. And they could be sources to look at. If you're recommending a policy, they could be good things for your organization. And with that, I'm going to turn it over to My left, Bill.
Well, we touched on this just briefly earlier. The question of when it may be appropriate to form an affiliate or subsidiary of some type, and exactly how that works. There are a number of reasons that a charity may choose to form an affiliate. It may be that it wants to conduct a particular portion of its activities through a separate entity, either for liability protection purposes, to isolate that activity and try to protect assets of the main charity from claims that activity may generate. It might be a need to have individuals on a board who can provide more specialized management for that type of activity. For example, a hospital, an educational institution, some organization that has a broad focus may choose to set up a separate endowment fund and may want to be able to invite onto that board people who have experience with fundraising and investments, but who aren't necessarily concerned with or interested in the broader issues of education or healthcare, things of that type. You also may be in a position where you want to isolate a particular activity because it might threaten your exemption. Either in some cases you will find a charity, a 501c3 charity that has formed a 501c4 social welfare organization affiliate, because 501c4s can engage in unlimited amounts of lobbying, and as long as the operations and structure of those corporations are sufficiently separate, the lobbying activities of that C4 won't be attributed to the C3 and run the risk of tainting it or causing it to fail the C3 test because of substantial lobbying. The same way with unrelated trade or business activity. As Phyllis mentioned earlier, a charity is allowed, even though the 501c3 rules say that it has to be organized exclusively for charitable purposes. The tax rules allow a certain amount of unrelated business activity, provided that that doesn't become the organization's principal activity or substantial purpose. Now, there are those vague terms again. What measure do you use to determine whether it's principal or whether it's substantial? So if an organization has an income-producing activity that may be treated as unrelated and therefore taxable, it may want to drop it into a separate taxable affiliate to protect the tax-exempt status of the rest of the activities. So there are any number of reasons that an organization may choose to form a subsidiary or other affiliate. Joint ventures also may be a case in point, although the IRS rules on joint ventures are not particularly helpful. Back until probably 1980 or so, the IRS just had a per se rule that participation by a charity in a joint venture with any private individual or entity, any for-profit investor, was grounds for revocation of exemption. You simply couldn't, under the IRS rules at the time, participate in joint ventures. The IRS lost a couple of high-profile court cases back in the early 80s and then retreated to its current position, which is that the IRS will allow a 501c3 to engage in a joint venture with for-profit investors as long as the activity that venture conducts contributes substantially to the achievement of the charity's exempt purposes. So, for example, a charity and private investors couldn't enter into a joint venture just to develop a shopping center, even though the income from the shopping center might be used to fund the charity's charitable activities. But they could, well, for example, a university that is a 501c3 could enter into a joint venture with a TV production company to produce course content that it then would use in its distance learning program. And even though the for-profit production company might be making money on it, because the overall purpose was to advance the university's educational mission, as long as the venture was properly structured, it would be allowable. The problem, though, is the IRS is being passive-aggressive about this whole thing, and they basically say, all right, the courts have told us that we need to recognize these types of ventures, but we're not going to tell you how to do them. That is, we're not going to give any general guidance. You can request a private letter ruling that may take a couple of years to process and cost you $25,000 or more just in filing fees, not to mention the legal fees and accounting costs and so on. And then we will evaluate your proposal, but we are not going to publish any guidance that is particularly helpful. So joint ventures are an area where charities in all events should tread very carefully, very cautiously. But the ones who do venture into that area, we do it through some sort of affiliate rather than the main charity itself. Now you see the last point up there is public perception. I have found instances where charities came in and said, we want to form, particularly in endowment funds, we want to form a separate endowment fund. We understand that we could just set aside money within our existing organization as an endowment, but having a separate endowment fund gives us an appearance of permanence, and we think that will help with our fundraising and so on. So there may be those types of reasons as well, but regardless of the reason, how do you do it? Generally, since most charities are non-stock corporations, often their affiliates are non-stock corporations as well. And as we talked about in the earlier part of the session, you can use a sole membership type of corporation, where the charity is the sole member of the affiliate to control it. You can have the charity, without being a member, just have the right to appoint the board, or to populate the board with its own officers and directors or employees through some sort of ex officio mechanism. So there's a wide variety of types of arrangements, and some of this, as we'll talk about 2 sessions from now, is influenced by the tax status rules that provide different set of rules for directly controlled subsidiaries than they do for ones that are more loosely affiliated. But these types of charities can be for-profit purposes if you're trying to isolate an unrelated trade or business activity for tax purposes, but they also, if they're conducting some phase of the charity's exempt activities, can be eligible for separate exemption themselves. And again, we'll talk when we get to the tax part in a couple of sessions about what those differences may be and how they influence the structure that you choose. Normally you wouldn't use a stock corporation because stock corporations have owners. Ownership is inconsistent generally with 501c3 status. So you might use a stock corporation for a taxable affiliate, but not for a tax-exempt one. There is one very esoteric type of situation in which that might be appropriate, though. If you have an exempt organization that is not a non-stock corporation itself, but is, for example, a state entity, a creation of state statute. There is a provision in the Non-Stock Act that says that a non-stock can't pay dividends, with an exception that it can make distributions to a non-stock corporation that is its member. Well, if the member is not a non-stock corporation, then you can't get any dollars upstream from that affiliate to the main charity if the affiliate is a non-stock corporation. But if the affiliate is a stock corporation, it still, in that limited instance, can qualify for exemption, provided that its organizational documents say these shares can never be held by any entity that is not a 501c3 or a governmental entity. But anyway, that was probably too long a rabbit to chase off to the side. For the point that in a few cases that you can have stock corporations as affiliates, even if they're intended to be exempt. Again, limited liability companies or partnerships normally are not in this position, just in part because they usually are not eligible for exemption either. They're not. A partnership is not a partnership is a pass-through entity, and therefore the IRS says it's not entitled to exemption. Now, the one exception, and this has become increasingly important over the last few years, is for a single member LLC, where the single member is a recognized 501c3. And this is becoming, in many cases, the preferred means of establishing a tax-exempt affiliate. Now again, this can be for any or all of the reasons we talked about before. Maybe to conduct a particular activity or hold a particular asset that raises liability concerns when you're trying to protect the assets of the main organization from any claims arising from that particular activity or asset. It may be a case where you need more specialized management for a particular activity or whatever. The key is that an LLC, unless it elects otherwise, is disregarded for tax purposes and is treated as simply a part of its member. When the sole member is an already exempt charity, the IRS has said administratively, we will treat the activities of the LLC as the activities of the exempt member, and will treat its income and expenditures as the income and expenditures of the member. Now what that means is from day one, as soon as it's created on a state level, that entity is exempt from federal income tax. You don't have to file an exemption application, wait the period of time that it takes the IRS to process it. It is automatically exempt. Not only is no initial application required, but that type of single member LLC also does not have to file annual information returns, separate forms 990. Instead, all of its income and all of its expenditures are shown on the 990 of its sole member. So just in the last couple of years, this has emerged as a very flexible way to create an affiliate for some part of a charity's activities. Now, this would normally be where you are trying to isolate some activity that's eligible for exemption, because if the activity is taxable, dropping it in an LLC doesn't help you in terms of protecting the tax status of the main charity, because again, those activities are just going to be treated as the activities of the charity. But in a situation where you have some portion of your exempt activities that you want to conduct separately, a single member LLC is increasingly attractive as the way to go. Now that's been around. The IRS announced in about 2000 or 2001 that it would honor these, treat them as part of their members for all tax purposes, or for all purposes. But there was a curious line in that announcement that said, we're still considering whether contributions directly to such an LLC are deductible. And everybody said, what? You just said you'll be treated as part of the member for all purposes. So why are you carving out deductibility of gifts? they said, we will soon state a position on that point. Well, you know, the IRS speaks in geologic terms, in terms of time, you know, as in Africa will soon drift into South America. So it took them 12 years to finally resolve that point, but they came out a couple of years ago with confirmation that not only are these types of entities disregarded for reporting purposes, but contributions directly to them are tax deductible and are treated as contributions to the single member. So again, keep that in mind. If you have an entity that is thinking about establishing some sort of affiliate, the first thing you might consider is a single member LLC.
Well, one thing to keep in mind, separate from tax status and exemption status for a single member LLC, though, is you know, if you are putting an asset down there or some operations down there that could generate liability, and that's your primary purpose for setting up a single member LLC, you want to make sure that you set up all the corporate formalities at that single member LLC, and that it is not just, you know, member managed and the members doing everything. There's no board, there's no officers, and something that could even create any kind of piercing the veil argument, so that, you know, the trying to put that asset or that liability down there gives you no benefit. So you have to go through the analysis and think about things, but you might have, you know, the single member create a board that does not exactly mirror the board of its member, or have some officers, and certainly follow meetings and formalities and things like that. So there's always you know, beyond maintaining the tax exempt status, there's always the other side of the governance piece to that too.
Yeah, that's a very good point, Mike. Sometimes we focus so much on the 501c3 aspects, you know, because that, of course, is essential to these types of organizations, that we forget about some of the other real-world consequences. One other one that I should mention is, if you are putting real estate into a single-member LLC, the question of whether that real estate still qualifies for property tax exemption. Because if it was exempt in the hands of, say, the hospital that owned it before, you put it into a single member LLC, that is disregarded for federal tax purposes, but it is not necessarily disregarded for state law purposes. And we've encountered situations in which an assessor had said, well, you just put it back on the tax rolls because it's not now owned by an entity that is recognized as exempt for state law purposes. Now, in some cases, you can have a conversation with the assessor and say, well, you know, if that's going to be your attitude, we'll just not put it in there, and it will stay off the rolls. But, you know, there are those types of concerns beyond just the attractiveness of the 501c3 rules. Now, I want to go back and talk just a little bit more, highlight a couple of things that Phyllis mentioned relating to filing and disclosure. If we're talking about the typical Virginia 501c3 non-stock corporation charity, there are a number of filing obligations that it has, and often we find, particularly in smaller or volunteer-run organizations, that over the years, some of the institutional memory gets lost, and a few of these things may drop off the radar with not good consequences for the organization. You know, first, of course, is that the charity has to file an information return each year with the IRS. Now, until 2007, that didn't apply to organizations that had $25,000 or less in average annual receipts. Beginning in 2007, however, Congress changed the rules so that every organization that is recognized as a charity, except certain religious-related organizations, has to file some sort of return every year. Whether it's a full 990, the 990EZ, which is for smaller organizations that still have some substantial income or assets, or the 990N, which is just a "we're still here" notice. You know, it doesn't require any financial information, but it is the annual checking in with the IRS. If an organization doesn't file one of those forms, whatever is the appropriate one, for 3 straight years, it automatically loses its tax-exempt status. And I can't tell you how many smaller organizations I have encountered that had lost their exempt status and didn't know it because they thought they were still covered by the rule that says if your receipts are less than, well, now 50,000, it used to be 25,000, you don't have to file. So there is no comparable Virginia filing that is with the Virginia Department of Taxation. But for federal purposes, you've got to file some form of 990 unless you're a church or an integrated auxiliary of a church. Now, if you earn taxable income, then you have to file a 990T to pay federal tax on that income. And again, you know, that's just sort of normal type of rule. You're not paying tax on the gross income. You are entitled to whatever deductions normally would be available in the production of that income, but the net amount then is subject to federal income tax and is shown on a 990T. In that case, then you do have to file a Virginia Form 500, the corporate income tax return, to pay Virginia state income tax on that same income. The corporation also, of course, must file its annual report and pay its annual registration fee to the State Corporation Commission to keep its charter in force. And as Phyllis mentioned, must file an annual form and pay a registration fee with the Virginia Department of Consumer Services to register to solicit contributions under the Solicitation of Contributions Act, unless it has filed and obtained an exemption from further registration. To the extent that the organization has certain types of gifts outstanding out there, for example, if it issues charitable gift annuities, and we'll talk more about charitable giving issues in a later session, then there are annual disclosure requirements that say that certain information has to be provided to the recipients of those types of annuities every year. So, you know, there are all sorts of tax-related filings, and then there are simply the other types of filings that you may have to do each year unrelated to your tax-exempt status, you know, whether it's an employment commission or, you know, whatever it may be. The thing that we, again, often lose sight of is that while these charities have all the very detailed tax rules to comply with, they also have the full range of other just business filings that any legal entity out there may need to make. In addition to those filings, you know, there's rules in the Internal Revenue Code that say certain documents have to be available to the public for inspection at the organization's principal office during regular business hours. And those basically are 3 types of documents. Number 1 is the Form 1023, the exemption application that the organization filed originally to get recognized by the IRS, and any related submissions. The second is the 501c3 determination letter that the IRS issued in response, as well as any subsequent updates that modify that status in some form. And then the third is Forms 990. That's all series, including a 990T taxable income return if you file one, for the last 3 years. Those have to be available for public inspection at the office, at the principal office during regular business hours. Generally, people can make those available on the web as an alternative, but it has to be a full and complete copy. The only thing that can be redacted from any of those documents is the donor list from the Form 990. And that's assuming the organization is not a private foundation. Also, there are some very definite rules about what happens if someone requests a copy of any of those documents. The IRS has procedures that it's put out. Generally, you're required to respond the same day to an in-person request. If somebody comes into the office of the charity has to be able to hand them a copy of these documents the same day. For mailed or emailed copies, requests, for example, the IRS gives the charity up to 30 days. There are some refinements, but those are the two basic rules. And the charity is permitted to charge reasonable copying costs and postage costs for fulfilling those requests. And the IRS says that a reasonable copying cost is any charge that is not more than the IRS charges for copies that it is required to furnish.
May I interrupt 1 second?
Please.
With regard to public disclosure, this is a little esoteric, but I wanted to make everyone mindful of it. There are a lot of the nonprofit, no, I shouldn't say it, there are a number of nonprofits that receive government funds or are quasi-government. For example, I recently worked with an educational foundation, which was an offshoot and established by a state board or a local board of education. There is an opinion by the FOIA Counsel, an advisory opinion, that depending on the amount of money they're receiving that is public, they may be subject to FOIA. And I just wanted to let all of you know that. And what is the substantial, nothing has been defined, but just be aware if there is significant government funding sources or set up by a quasi-governmental entity, they may be subject to all the public disclosure laws of FOIA, including emails and everything else.
Yeah, thanks, Phyllis. That's a very important point. The FOIA Council, I think, had put out some guidance at one point that said unless you got at least 2/3 of your total revenue, you weren't considered to be supported primarily by public sources. But all of that is up in the air at the moment. There was legislation introduced in this most recent session of the General Assembly that would have made any foundations affiliated with state entities subject to FOIA in full. Legislation didn't pass, but it may come back. And in any event, there is active litigation now involving George Mason University and its affiliated foundation, where a group seeking information about some donations to George Mason has filed a Freedom of Information Act suit, again arguing that the George Mason University Foundation, even though it is a entirely separate legal entity, corporation, from George Mason University, is subject to FOIA. So that's one thing that is going to be, I think, having the potential for some major developments in the next several months, next year or so, both the legislative level with anything that may be introduced into the General Assembly, and this litigation, which I understand is only one of several suits that either are pending or are planned out there relating to FOIA status. I guess our final point here on this is simply that, as Phyllis has pointed out, the 990 asks a lot of sort of leading questions. I mean, this is kind of push polling, if you're familiar with that term. You do a poll, but you phrase the question to push people toward the answer that you want, and that's what the IRS is doing. It has no legal authority in the area of corporate governance. That's entirely a state law matter, but at the same time, it has very definite ideas about what good governance means. And so it is asking a lot of these questions on the return, trying to encourage people to provide yes answers. Yes, we have made all documents available. Now, some of them are statutorily required, but yes, we have had the board review the 990 before it's filed. Yes, we have a conflicts of interest policy and these 17 other policies that the IRS recommends and so on. But it is something that is garnering increased attention from the IRS, from donors, from public interest groups. And again, as Phyllis mentioned, the Give Richmond site run by the Community Foundation is a very convenient way for organizations to comply with a lot of these requirements and provide information that their donors or potential donors may be interested in. So it also may be something that you want to do if you get paired up with a charity. Go see what's out there on Give Richmond, on GuideStar, where you can get copies of their 3 most recent 990s. Check around, do a little due diligence to see what sort of organization you're being paired with.
May I interject one other little thing? The 990 is an interesting form in that it gives plenty of space and attachments to explain, to write, and the artfulness that an organization uses in completing that 990. If they treat it merely as a tax form, it has little information. They could, just as lawyers can do, create this wonderful package that looks great and reaffirms itself. And most of the organizations are simply not aware about these extra attachments that you can put on that allow you to explain what you're doing and explain it in a way that a layperson could understand.
And that's very important because donors increasingly know about the 990, and that's the first place they're going to go look if they want to find some information without going directly to the charity. So, for example, if your organization gives out scholarships and depends on public contributions to fund that effort, for the 990 purposes, you can show an expenditure that says, $50,000 scholarships. And that's perfectly adequate for 990 for IRS purposes. But just think how much more effective it would be as a PR tool for the organization if instead it said, $2,500 scholarships awarded to individuals who were the first in their families to attend college. A very simple addition to the 990, but it makes the case.
Absolutely. Thanks. On the next slide, you'll see there's a list of some resources. One of the resources I just want to point out in particular is this Good Counsel book by Leslie Rosenthal. She works, I think, at the Lincoln Center. She's the general counsel. This book, and Phyllis pointed it out to the task force, and we've all been taking a look at it, and the foundation is looking at getting some copies and making some copies available to anybody who volunteers with this program. It's a great overview. It's got some great work plans, checklists. Highly recommend it. And like I said, we're working to get some copies, and we will have some copies available for folks. But some of those other resources are also good. Commend those to you, and we'll get around the link to the Stanford website.
I was going to say the Good Counsel is available electronically at University of Richmond Law School Library as well.
And one other resource that you may not think about initially is the IRS website, irs.gov, and they have a tab for charities and nonprofits, and there is a surprising amount of good information on there. Now you have to consider the source. So where there are debatable issues, the discussion slants it toward the IRS position. But just in terms of the filing requirements, they have something that's called the life cycle of a public charity, and they have another one called the life cycle of a private foundation that takes you through formation, the early operations, later stages, dissolution. Just as the name implies, it's kind of an overview of the things that you need to know, tax-related things that you need to know when dealing with those types of organizations. So there's some good information there as well.
And also on the website for IRS, they've stopped doing continuing professional education CPE briefs. I think they stopped in the mid-90s at the latest, but many of them, and there are hundreds of them, they are very thorough analysis of the development of the law and general counsel memorandum and their positions. So in trying to get an understanding and a feel of what IRS's position is and has been on various topics, these are wonderful.
Agreed. Well, I should have started off the program by first, and I want to do it now, thanking all of you for all the work that you probably likely, and I know many of you definitely, do with, for pro bono and for nonprofits, whether it's sitting on board or whether it's providing legal advice. We appreciate that. I know many of you are already volunteers with our pro bono clearinghouse. Thank you for that. Please continue to do that. And if you're not and are interested in becoming a volunteer through the clearinghouse, other than through this program, generally, see me or Allie or Allison, but thank you for all that. And also just want to reiterate, I know we went from 30,000 foot level down to dusting some crops here today, and I understand there's some details. There's a lot of material in the slides. There's a lot of resources. The goal of this program, and what you'll hear over the next 4 training sessions, the goal of this program is to introduce you to these things so that when something comes up or you hear the executive director say something, you can hey, say, ooh, I think that rings a bell. That might be something that was covered in one of those programs, or reach out to one of us and help them address it. Yeah, thank you all for coming, and we're happy to answer any questions that you guys have.